May it please the court. My name is Brandon Perkins, and together with Alex Brockmeyer, we represent Maximilian. We'd like to reserve 2 minutes for rebuttal. There are two basic issues in this case. Both issues relate to the statute of repose for mortgages. The statute of repose is found at 95.281. I'm going to first start out talking about subsection 1C, which is the statute of repose for the payment of taxes. In the second half of the argument, we'll talk about 95.281 1B. The statute of repose for the payment of taxes by
before you jump into the law, the facts on this are that the promissory note has a due date, and if there was an extension, it wasn't a recorded extension. Is that what we have? Yes.
Let me back up, and I'll go through a brief chronology of some of the facts. We have a mortgage, and the mortgage states the mortgage secures a debt. The debt is evidenced by a note, a promissory note. The promissory note in the mortgage states the maturity date it matures on, December 30th, 2006. But in that same sentence, it says, provided, however, any extension, renewal, substitution, modification are jointly and severally termed the note. Then if you read what obligations are secured by the mortgage, it's the obligation to pay the debt from time to time as evidenced by the note. So what we have is Maximilian paid the taxes in 2010. There was an unrecorded extension that extended the time to pay the principal debt under the note. That extension was also the note, and that unrecorded extension extended the time to September 30th, 2007, and a lawsuit was filed in July of 2012. It is our position that
Did you sue on the note as well as the mortgage?
Yeah, we did a mortgage foreclosure alleging default based on the failure to pay under the note, which includes the extension, and failure to pay the taxes.
But you didn't sue?
We did not do a note
separately on the note?
No, Your Honor. That's sometimes
because the statute of limitations on the note the extension would not have needed to have been recorded for purpose of a simple suit on the note, right?
Right. No, it would not have. Nor would it have needed to be recorded for if you do a mortgage foreclosure, looking to recover based on the security, and that's what we did. For the taxes were paid in 2010. We filed an affidavit in opposition to summary judgment that states the taxes were paid in 2010. Now, the statute of repose for the payment of taxes is at 95.281 1C, and it states for all obligations, including the payment of taxes paid by the mortgagee, the statute of repose is 5 years from the date of payment. Now, if we paid in 2010, the statute of repose would expire in 2015. The payment of those taxes are secured two different places. First, they're secured by the mortgage. The mortgage expressly states any taxes paid by the mortgagee are secured by the mortgage. And then if you look at the future advance clause, the statute, which is 697.041B, it states even if there's not a future advance clause in a mortgage, the payment of taxes by a mortgagee is secured by the mortgage.
So I want to make sure I'm clear on this. Are you arguing then that under 2C, you're entitled to bring a lawsuit for the amount of these payments, even if you can't bring a claim for the amount of the note?
Oh, absolutely. They're independent. And the way I get there is this court's opinion in Razik. What this court did in Razik...
I mean, I guess the flip side is, are you arguing that 2C lets you try to collect on the note as well as for the taxes, or are you aimed at the taxes on this one?
Okay, it can be either or both, and let me explain. If you read the obligations secured by the mortgage, it says the obligations are joint and several obligations, and so they join in the payment of taxes and the debt. So just the failure to pay one would be a default on the other as well. But even if this court decided that we were precluded from collecting the principal amount of the debt, we're still not precluded from collecting the taxes that we paid in 2010.
But you didn't sue separately to get the taxes. You sued to foreclose the mortgage, right?
Right, based on violations of the obligation. And if you look at the verified complaint, The verified complaint lists the default, and one of those default items were the non-payment of taxes. We noted that separately. We also had the non-payment of the debt. There were multiple violations of the note giving rise to the mortgage foreclosure. And so Beau Rivage has taken the position in its brief that the only way we could secure the payment of taxes is if we subrogate it to the paramount lien of the state. And I would agree that one way you could have a lien for the payment of taxes is if you subrogated to the lien of the state through a written assignment with the state, but that's not the only reason.
Let's say I'm trying to look at this and figure out, I'm a title examiner, and I'm trying to figure out if your mortgage is barred by the statute of repose. And I look at the mortgage, and it says the note's due December 30th, 2006, 5 years. That makes it December 30th, 2011. I don't see a recorded extension agreement. Are you telling me that I've now got to go check and see who paid the taxes and find that out too, to make that determination? Is that it?
It's more than just that, Your Honor. What you have to do, if you look at this court's opinion in Pitts what we had is we had a mortgage that was recorded. Attached to the mortgage was an overdue promissory note. A lawsuit was filed more than 5 years after the overdue promissory note came due, and this court stated that the conflicting language in the mortgage, which called for a $21,500 debt, and the overdue promissory note, which was only for $20,000, creates this idea that there must have been an extension that's unrecorded.
How can I find out who paid the taxes? I mean, if I'm examining the title, my only real interest is to see, well, are the taxes paid for any particular year? Now you're telling me I got to check each year and see who paid the taxes, go talk to the tax collector and see who they issued their receipt to, in order to determine if the statute of repose has barred the mortgage?
No, it's easier than that, Your Honor.
Yes,
all you would have to do is either send an email, a letter, or pick up the phone and call the mortgagee and state, can we have an estoppel? And if they say no, you can state, well, it seems to be that your mortgage is expired, and they could say, no, we extended. If you look at this court's...
Suppose nobody will respond to my email or talk to me when I call them on the phone, or I just get into a phone maze and I don't get anywhere.
This court's opinion in Huntington addresses that. They say you have no right to presume that a mortgage is satisfied or extinguished unless there's a satisfaction of record. You can't presume it. So if you're a title examiner, you should not be presuming that a mortgage is satisfied or extinguished if there's not a satisfaction of record. And in that case, it was...
So why have a statute of repose at all then?
Well, the statute of repose basically is so that we don't have problems in title for many, many years, but you would, even with the statute of repose, you would bring a quiet title action to clear it up, and there would be a lawsuit, and we would be here to resolve who's right and who's wrong. I agree with the idea that the legislature could make a black and white law. Instead, they said, for any obligation secured by a mortgage, that if the final maturity date is ascertainable. They use the word final, not just if the maturity date is ascertainable, and so they use the word final maturity date. So the legislature has made this situation where...
Well, it seems to me, though, that this language that you're talking about, saying the note is, or the mortgage secures extensions and advances and taxes and all that stuff is general language. So if you interpret it the way you do, then there's no point in looking at the maturity date of 5 years, because they'd all be extended.
Well,
everything would be 20 years instead of 5.
I don't agree with that, because if you look at this court's opinion in Razik, what we had in Razik is Mr. Razik was arguing by merely including a future advance provision in his mortgage, he created a 20-year mortgage for both his note and any future advances. And this court said, no, if there was future advances actually made, yes, you would have that security. You didn't make future advances, therefore the note is expired. So what I'm saying is, if there was actually an extension made, yes, we would have that, it's secured for up to 20 years. We made the extension. The extension is jointly and severally termed the note.
But the extension has to be of record.
No, the extension only has to be of record if you're extending the statute of repose. We never needed to extend the statute of repose because this mortgage was always valid for 20 years by using that specific language.
So the fact that it had a due date for the note, the fact that it allowed for the possibility of an extension in it means that it wasn't, that the due date wasn't ascertainable from the record?
Yes, because it not only allowed for the possibility of an extension, but because also the extension was jointly and severally termed the note. I cited...
Is there a case that says this?
No, there is not. I admit that this area, the issue of taxes, I think is separate. I think that's clear cut. This issue is a gray area of the law. But if we look at Pitts and the way...
But I got to come back to the earlier question. If your argument were to be accepted, then since this mortgage, you'll agree with me, this language is general in mortgages, correct?
No, I disagree.
No?
If you look at a residential mortgage will have a clause in there that states all payments and obligations due and owing hereunder are due and payable on or before such and such date. That's a final maturity date. They usually don't have extensions, modifications that are jointly and severally. This is for a...
But any mortgage that does then, you're saying you can't determine the date of final maturity, so it's automatically 20 years. Is that right?
Yes.
And that would be true for commercial mortgages.
And the reason for that, Your Honor, is in the commercial setting, you would have a one-year balloon note, let's say, for a business. And the balloon note or the mortgage would say, subject to renewal from time to time.
So those mortgages are all 20 years as far as the statute of repose.
Right, because if they renewed the note, let's say they renewed it for 3 or 4 years in a row.
They don't record an extension agreement because they could.
No, right, but they wouldn't need to because the language expressly securing any renewals and saying, heads up to the world, we can renew this note, and the renewal note is treated as a note.
So all you have to do is say, we could renew it, but you don't have to. And,
yeah.
And the 20 years is the what you have to look at.
Absolutely, because we could have just deleted the provision in there about the maturity date to begin with, the original maturity date that described the original note. We could have put in there the final maturity date due and owing herein is the longest extent provided by law. These rules, the statute of repose, isn't there to stop banks and customers from entering into relations. And when you have a commercial bank loaning money to a commercial borrower, we want the flexibility so that you can have renewals without worrying about every time we do a renewal, we got to run down and do another recording. And that's why in the commercial context, this is separate. And there's not a final maturity date.
You're saying banks fake extensions like that and don't record extension agreements?
Absolutely, Your Honor. When the mortgage itself references the extension agreement, you would not need to record it. Pitts is a prime example where this court authorized and said the record below shows that there is an unrecorded extension agreement.
Well, what about in 95281 section B2 where it talks about an extension agreement being recorded?
Right. If you need to extend the statute of repose, if you need that provision, then yes, you can record an extension agreement to extend the statute of repose. But we didn't need to extend it. It was always 20 years based on the language of the mortgage. And that's really the heart of the principal debt argument. The mortgage states the obligation secured hereunder is the obligation to pay from time to time the sums evidenced by the note.
What's the case that would support that argument?
The case that supports the argument you don't need to record an extension?
That it's always 20 years if you have these additional obligations that are supposedly secured by the mortgage reference.
Right. This is a gray area of the law. There's only about 20 cases in all of Florida dealing with 95.281. If there was a case right on point that said I was 100% right, I would come in, I would show it to the court.
There isn't a case.
No, but what we have to look at is we have to look at the lines of cases. Starting with Pitts, we go to Irwin v. Cole. Irwin v. Cole acknowledged an unrecorded extension. Pitts acknowledged an unrecorded extension. And then if we go to Huntington, which is out of this court, we're talking about a mortgage with this language securing extensions, renewals, modifications. And in that case, in Huntington, we had a mortgage that secured a note that didn't even exist. And the parties went back and they were doing a reformation of the mortgage saying, hey, we meant to secure this note of a different date, and there was a lawsuit over that, and this court noted, well, the mortgage itself said it secured renewals, extensions, modifications, substitutions. We're going to allow the reformation. In the commercial setting, this is the language because banks want a 20-year mortgage. They want the ability to renew, modify, extend with their customers, and that's what we have here. Unlike a residential, where you generally have a clause that says all obligations due and owing hereunder are due and payable on X date, and that's it. That is a final maturity date because it's saying any outstanding obligation is payable. If we go back to the tax issue, statute of repose for payment of taxes, very specific in that regard. Therefore, we have 5 years from the date of payment. We paid in 2010. We can bring the mortgage foreclosure up to 2015 on that issue. In addition, attorney's fees. If you look at the cost and attorney's fees, they're separately secured by the mortgage. Therefore, we have 5 years from the date the client pays the attorney's fees to bring a foreclosure. Okay. Thank you, Your Honor. We will reserve the remainder of time for rebuttal. I would urge this court to reverse the lower court's judgment.
Thank you.
May it please the court, Susan McLaughlin for Beau Rivage. Let me just, I believe the court understands this, but my client is not the one who borrowed the money. My client is the condominium association that foreclosed on the original debtor on the note for non-payment of maintenance assessments, which run over $10,000 a year. Maximilian is not a bank. It didn't make the original loan. It acquired the loan. The assignment was not recorded until right before the suit. My client foreclosed on this unit in 2010, having not been paid since 2007. Maintenance assessments run over $10,000 a year. Maximilian, we knew that they held the note, and they consciously chose not to start an action to foreclose its own interest on the condominium unit because they didn't want to pay the assessments. It's a penthouse that's not finished. It has no flooring, no toilets, no fixtures in it. So they made a conscious decision to wait. And there's just no question that the mortgage states that the date for final payment, as stated in the note, is December 30th, 2006. Now, I think the court recognizes there's two transactions involved in a case like this. There's the loan, which doesn't involve my client. And if there was an extension of time to pay the loan and they had sued the debtor, then there wouldn't be this issue. They'd still be able to...
You're only potentially liable on the loan.
We're not liable on the loan. We took the other part of the transaction is a mortgage lien. Now, the mortgage lien can impact on the rights of third parties, and that's why it has to be recorded. The extension on the loan doesn't have to be recorded because it doesn't affect my client.
How then do you respond to his argument about the final maturity date not being ascertainable from the record because of the additional language in this particular document?
Your Honor, that just doesn't make any sense. The language in this note allowing the borrower to make future extensions or additional loans is standard. And it's allowed by statute that the extensions may, any additional loan money extended during the period of the loan, the priority of the lien for that money relates back. And that's what the Huntington National Bank that is stated deals with. In that case, the issue was that the party in my position was arguing that they had a right to believe that the maximum amount of the mortgage was $500,000. And the court said no, because there was that language in there allowing them to add money to the loan, and which would relate back to the original amount of the lien. But this isn't a case about how much money was owed. It's about the priority of my client's interest as the lien holder for the condominium assessments, and then the title holder on the unit by foreclosure. So,
But the statute discusses the termination of a lien following certain periods of time, and if it's non-ascertainable, it's 20 years, and if it's ascertainable, it's 5 years, right?
but it is ascertainable. It's ascertainable as December 30th, 2006, unless extended. And in order to toll the statute of repose, the recording of that agreement to extend the date for final payment has to be actually
Your
recorded.
argument is then that the less extended language in these documents doesn't relieve them of the obligation to record it to place
Exactly.
people like your client on notice.
Your Honor, even if that language had not been in the original mortgage and note, allowing for future extensions on the loan or for additional money to be advanced.
So the
they can-
language only relates to a future advance, not an extension of the maturity date?
It could relate to either. Even if the language wasn't in there, the duty to record the extension of the date for final payment still exists. Any agreement can be modified or extended, but if they want to extend the date for final payment in the public records, they have to record that extension. If they want to extend the lien stemming from that date. We're not talking about how much money is owed.
Pitts versus Pastore doesn't seem to require that.
Now, in the Pitts versus Pastore case, the parties recorded a mortgage with a date of final payment that came up before the mortgage was recorded. So that obviously that could not be the date for final payment because it already occurred before the mortgage was recorded. So in that case, you didn't know you knew that the date in the mortgage was not correct.
Right.
So that rendered it additional. If you look at the Irwin versus Grogan case, which is cited by my opponent, they say in there, although the person in my position lost in that case was for another reason, they had actually acknowledged the existence of the mortgage. But the court in Irwin versus Grogan said that even though that was a 7-year balloon note, if you added up the schedule of payments, you still had $300 left over at the date for final payment as stated in the mortgage. And the court stated in the Irwin versus Grogan case that mistake in math didn't change the fact that there was a date for final payment stated in the mortgage, and the statute of repose ran from that date. Now, the owner of the property lost in that case because they had actually acknowledged the existence of the mortgage in written agreements. So that had nothing to do with that. Also, the Razek case, Razek versus Marina Club case that was cited by my opponent, that deals with that issue of the right to make future advances on the loan that would relate back in terms of lien priority to the date of the recording of the original mortgage. And the court didn't say in that case that it doesn't matter if you don't make that. The question was, well, how much is the loan? The question isn't when was the date for final payment. The date for final payment was still the same because there was no recorded extension of it. So, I mean, the issue of whether they could make future advances really has nothing to do with this case because we're not here as to what the amount of the loan is or the amount of the lien is. We're here as to what was the date for final payment as recorded in the public record. And that's very clear. And there was no recorded agreement to extend that date. I would like to...
the argument that even if the lien as to the main obligation has expired, that the lien as to the taxes paid in 2010 has not.
I was just going to address that. Again, that goes into the future advance issue. The mortgage holder has the right to, under the agreement of the loan, come in and pay taxes to protect its lien priority, all right? Because If the taxes aren't paid, the tax deed holder can come in. So if the mortgage holder makes that advance to pay the taxes to protect its lien priority, it can add that to the amount of the loan, and the lien priority for that payment relates back to the recording of the original mortgage, and it increases the amount due. But it does not change the date for final payment as recorded in the public record. Also,
But it says, the statute says the lien shall terminate 5 years after, get this right, shall terminate after the expiration of the following periods of time, and for obligations including taxes, 5 years from the date of payment.
but they didn't sue for repayment of the taxes. They sued to foreclose their mortgage lien. Okay, if they...
Yes, my question is, to the extent that that at least an element of this is those taxes, is that still open?
My client isn't responsible to pay them any money. We're not a party to the note. The only question is, can they take title away from us on that property? All right, do they have a lien that is superior to our title interest? And they did not sue for payment of, my opponent misstated my position on the subrogation interest. The subsection C of subsection 1 of the statute says is it actually preserves a separate right for a mortgage holder who made an advance in defense of a position that was extinguished. It gives them a separate right of action, but just for the money paid on the taxes, not for the mortgage, for the amount of the mortgage. And there is no suit here for subrogation against my client. The subrogation claim isn't against the state. The subrogation claim would be against my client because my client took title to that property in 2010 after they had paid the taxes.
And as I understand it, there was no separate claim filed here for recovery of the amounts paid for taxes. Is
No,
that correct?
that's correct.
Is there an argument below that even if we lose and everything else, we should be able to get our payment of the taxaxes?
No, Your Honor, they're not asking for payment of the taxes. They're asking for foreclosure of their
So this issue
lien.
wasn't raised or preserved below?
It was not. They are arguing that because they paid the taxes in 2010, their original mortgage lien starts all over again from 2010. And it doesn't. The priority for that payment of taxes relates back to the recording of the original mortgage, which was in 2006. So they have a right and interest in priority to lien for that tax money over anybody who came after them in interest running from 12/30/2006.
You know, on that theory, you could go in and pay the taxes and keep things going indefinitely.
Right, and you could not have found out really who paid the taxes because they never had a recorded assignment of this mortgage. You couldn't call them up and ask them for an estoppel letter. They didn't have a recorded assignment of this mortgage until right before the suit was filed. So that really has nothing to do with it. But the payment of the taxes, the subsection C of the statute preserves for a lien holder who went in and paid money to protect its lien priority to get that money back if somebody else takes the property from them. And that's what we did.
That's almost like an equitable subrogation.
Right, it's a subrogation claim. It doesn't have anything to do with the mortgage for the loan. The mortgage is for the loan, all right? And subsection C says, deals with the situation, well, what if I thought that I had a lien on this property and I paid the taxes so the tax deed holder wouldn't take the property from me, and then it turns out that my lien was inferior to somebody else's, namely my client's. Then can I get that money back? Yes, I can. And they would still have till 2015 to sue my client for reimbursement for the tax money. They didn't sue my client for reimbursement from the tax money. They sued my client to divest them from title to the property. And, you know, again, I want you to understand that we didn't borrow the money. We didn't stiff them on the loan. We foreclosed on the unit because we were owed over $20,000 or $30,000. At this point, it's probably $50,000, $60,000 in maintenance assessments that were never paid on that unit. So we're not somebody who came in and swooped in and did a gotcha on them. They knew that we took title. That was a matter of public record. They chose not to take title from us until they got good and ready to do it because they didn't want to take responsibility for the unit. And they waited too long. I don't know why they waited too long. Perhaps they thought the extension was recorded. Perhaps they read the note wrong. Perhaps, and they didn't, by the way, pay the taxes for 2011 or 2012. My client paid them. So, they had at one point abandoned the property and then came back and thought, well, maybe we don't want to abandon the property. They changed their mind. They simply waited too late. So my client isn't getting a windfall. My client has been maintaining this property that is a very expensive piece of waterfront real estate. It's a penthouse condominium. My client's been taking care of this property and maintaining it since it was CO'd in 2006. And there's no inequities here. They waited too long to foreclose their lien. And again, all the cases that are cited just say the opposite of what they're purported to say. They support my position. The date for final payment is very clear in the mortgage. There was never a recorded agreement to extend that date. And therefore, the statute of repose expired. And the statute of repose, when the statute of repose expires, it doesn't just bar the right to bring the claim. It extinguishes the claim itself. It's gone. It doesn't exist anymore. There's no equitable reasons that this can be extended, no discovery periods, nothing like that. It's gone. Their lien on the property is what is at issue in this case, not their payment of taxes. They want to lien on the property for the money they loaned to the original owner of the property. The original owner of the property was divested of title by my client that had a lien for maintenance assessments, which was, at the time we took title, subject to a mortgage. But the mortgage lien expired. We weren't subject to the loan, we were subject to the mortgage lien. And that lien was extinguished and completely rendered a nullity upon the expiration of the statute of repose, which ran 5 years after the date for final payment as shown in the public record, unless there was a recorded extension, which there never was.
Okay, thank you very much. Mr. Perkins, rebuttal.
Yes, Your Honor.
Sorry about that.
Okay, so let me start with 95281. That is limitations, instruments encumbering property. So we're talking about something that places a lien on property. It states the statute of repose for taxes is 5 years from the date of payment. If we pay the taxes, we have a lien on that property because that's an instrument encumbering property for 5 years from the date of payment.
Did you allege below that you wanted taxes paid, and have you preserved the argument?
Absolutely.
Yes.
Absolutely, Your Honor. Let me go.
Where in the record can I find that?
Okay. And in the complaint, paragraph 10, it says the mortgage is in default by virtue of a tax lien was issued against the subject property. The plaintiff redeemed the tax certificate to secure its interest. We allege that as a specific default. In the record, the transcripts of the summary judgment, page 20, I stated, this is an easy argument. Section 95281, paragraph C says, hey, if you have to pay the taxes, you get 5 years from the date you paid the taxes. We paid the taxes in 2010. We have got 5 years from the date we paid the taxes to bring a foreclosure suit. I go on to develop the argument. We filed an
Did you have a separate count for recovery of the taxes, or was this all wrapped into the claim for the mortgage indebtedness, interest, attorney's fees, etc.?
Right. We did one count for mortgage foreclosure, and we broke out several different reasons that we're entitled to recovery. So even if the court said you can't recover on one of the obligations, okay, let's say we couldn't prove up something, we can still recover on the others because we alleged it in the complaint specifically. We paid the taxes in 2010. We filed an affidavit in opposition stating we paid the taxes in 2010. And the statute of repose, 95.281, says you have 5 years from the date of payment. Nobody's arguing.
But you don't want us to reverse and remand for you to collect $10,000, do you, or whatever the taxes were?
Absolutely, Judge. The taxes were $50,000 plus interest from 2010, and It doesn't the money
The
doesn't
annual
matter.
property taxes in 2010 were $50,000 in this piece of property?
If you look at, excuse me, Your Honor, I didn't hear that.
It's a nice house.
The mortgage is 1.7 million. We attached to the affidavit in summary judgment, the tax certificate where we paid it, over 50,000, plus interest. Look at the affidavit, Your Honor, and that's what you'll find, that it's over 50,000. So yes, I do want you to reverse so that we can foreclose on this mortgage. It wouldn't matter.
No, that wasn't what I asked you. I asked you if you would be happy if we reversed so you could collect whatever it was you paid for the taxes and nothing else.
Would I be happy? No. My happiest, Your Honor, is if you totally reverse and you find that we can collect the debt and the taxes. If you, as a collective body, do not do that, my fallback position, at least let us go in and foreclose for the taxes.
You won't be happy, you'll just feel good.
Thank you, Your Honor, yes. We would ask for you to reverse. Thank you.
Okay, thank you. That concludes the oral argument portion of our docket. Court's adjourned.
Yeah, I know.